Hi everyone, my name is Allison Grosz. I'm an attorney and a partner with Hemrick O'Malley, PLLC in New York City. Today I want to talk about a somewhat new policy that the EOIR, or the Immigration Court, has passed through the Department of Justice in April. Now, what I'm going to talk about today is something that has lasted for quite some time. However, the Department of Justice just recently announced that they are going to start encouraging immigration judges to take more notice and practice the concept of pretermission of asylum applications more frequently in situations where the immigration judges or the immigration court determines it's necessary. Really quickly, pretermission of an asylum application is the judge's determination that an asylum application, as it's been submitted to the court, is not legally sufficient in order to state a claim that can win the asylum case on the face value. What that means is that when an applicant for asylum submits their asylum application to the court accepts the application and will usually schedule a person for a final individual merits hearing. Now, if a person's application for asylum, which requires mostly biographic information, but also requires certain boxes to be filled out about the reason for an asylum application's being filed, if those boxes are not completed to legal sufficiency and/or if a person's detailed asylum statement is not submitted along with a person's asylum application, well, an immigration judge can determine that a person has not submitted a legally sufficient on its face value application to state a claim for protection in the United States. In so determining, an immigration judge can pretermit, or basically determine the application to be abandoned. Pretermit is just another word for considering an application abandoned for it not being on the face something that can win after an asylum hearing is done. The reason for this is because the immigration court, who is, as we all know, extremely backlogged, doesn't want to spend the time to schedule an entire hearing for a case that may not actually be legally sufficient or legally viable to actually win after a full hearing. Now, this can be overcome by the complete submission of an asylum application that includes all necessary details, including the boxes to be completed on the asylum application itself, as well as also submitting, of course, the necessary detailed statement in support of the asylum application that comes from the asylum applicant. It's important to speak with a qualified immigration attorney when you're preparing your asylum application to make sure that it's not going to be pretermitted so that you can have a full and fair hearing before an immigration judge. We here at Hemrick O'Malley, of course, prepare people's asylum applications every day. We work with people on preparing a full and, of course, facially sufficient, if not far more than that, asylum application to submit to the immigration court or, of course, to the asylum office. We're happy to hear from you, and we're happy to answer any questions regarding this pretermission issue, any asylum matter, or any other immigration matter. You can find us online at hemrick.law, or you can call us at 833-848-7838. And until next time, I look forward to speaking to everyone soon.